My name is Nick Elliott. I do commercial work and employment work at Hopkins. I tend to divide my time between the Mansfield and the Nottingham office. I'm going to be talking today about employment law, more specifically about redundancy, and talk about the rights of the employee and the general process that the employer needs to go through when making people redundant. Redundancy is where the need for a certain employee to carry out work of a particular kind is reduced. The employer must act fairly and reasonably in all the circumstances, and this means making sure there's a proper redundancy situation, i.e. making sure there's no longer a need for employees to carry out that work of a particular kind. They must also make sure that they select the redundant workers from a particular pool of people, i.e. other workers that carry out the same sort of work. And also the employer must go through the proper consultation with the employees before making anybody redundant. The employer's got to carry out the consultation process with the employee, which means essentially sitting down with the employee and going through the redundancy process with them to explain why the redundancies are taking place, to explain why their job might no longer be needed, and the employer might want to discuss other possibilities with the employee, such as job sharing or voluntary retirement. At the end of the consultation process, the employer has to discuss with the employee to determine whether their job role has in fact been made redundant and give the employee the right to appeal. With the statutory redundancy payment, the employer has to make sure that the employee has all their contractual rights, such as the notice period and holidays accrued but as yet untaken. The basic award which the employee is entitled to under statutory redundancy pay is based on the number of years continuous level of service, based on a multiplier of their age. If the employee thinks that any part of the redundancy was unfair, either with the actual redundancy itself, with the pool of employees that were chosen for the redundancy, or in fact if the consultation process was not followed correctly, then the employee could have a claim for unfair dismissal against the employer. In redundancy situations, the employer will often get the employee to enter into a compromise agreement. This is where the employee effectively signs away all their rights to sue the employer under employment law and often under contractual law in relation to their employment contract. The compromise agreement is protection for the employer, but the employee does not necessarily have to enter into the compromise agreement if they don't want to. So very often in these circumstances, the employer will offer extra compensation that the employee otherwise wouldn't be entitled to persuade the employee into entering into the agreement. Employment law is always changing and is regularly updated, and so for up-to-date information, it's always best to seek legal advice. Thank you very much for watching this video. If you require any further information, please contact me or check our website for further information.